Booyah, right on the second again, punctual to a point of absurdity. Good evening, everybody. This is a Saturday night live stream. Oddly enough, this stream is probably going to be funnier than Saturday Night Live. I'm getting a warning sign that we're having trouble streaming to Rumble. Okay, we may not be able to stream to Rumble tonight. Darn it. Okay, we might not be able to stream to Rumble. You can all hear me, I imagine. The Fs are an indication that I am loud, clear. Wearing a new shirt, by the way. I don't know if anybody noticed this. I finally picked up the dry cleaning about 6 months late. Okay, so unfortunately, it doesn't look like we're going to be able to stream this one on Rumble. I'll post it to Rumble tonight or tomorrow. So my apologies, everybody. Yeah, a Saturday night live stream. I like the way it sounds. I even think spiritually, it might be better for some who are so conditioned to the Sunday stream. You're going to wake up with an extra date of the weekend tomorrow. Okay, so it's going to be amazing. Before we get into anything, we'll get to the menu. We will get to these standard disclaimers. Let's just begin with what has now become the standard Viva rant. They arrested Artur Pawlowski, the Alberta pastor, the Polish pastor who was known for screaming, "Get out," and yelling at the police who came to his church to break up one of them illegal gatherings. And he was arrested today. Actually, he was arrested today after Ezra Levant and I and Michaela Peterson were on Dave Rubin yesterday talking about how we have fallen off any cliff of the semblance of civil rights in Canada, and too many people seem to be too keen to go along with it. Ezra Levant was warning yesterday that he has a feeling that we are about to arrest a second pastor in Canada. And 24 hours later, Artur Pawlowski and his brother have been arrested. Now, the news is breaking. I was just reading from CBC, state-sponsored news that disables comments on their YouTube channel. And it just says Calgary police have arrested 2 organizers of church services who have been defying public health restrictions throughout the pandemic. And in a release, police said the Pawlowskis, quote, acknowledged the injunction, but chose to ignore requirements for social distancing, mask wearing, and reduced capacity limits for attendees, and went ahead with the event being church services. It is, whether or not you think it's absurd just depends on your perspective on life. There are a lot of people saying they should just follow the rules. Just follow the rules and they'll have no problem. And a lot of other people are saying, first of all, just following the rules. I hate to use the ever abused analogy, and I'm not going to use it, but just following the rules when the rules are fundamentally unjust, some people have a problem with that. Other people say, just follow the rules, and if you get a ticket, fight the ticket. And other people say the rules are absolutely preposterous, unscientific, unproven, and just as a pure matter of fact, if we take the Pastor Coates, Canada's first pastor, who was jailed for 35 days, 2 weeks of which was solitary because of COVID restrictions. He was jailed for 35 days for 2 underlying health violations, which themselves did not carry any jail time, but breaching bail orders did. One person, apparently, I think at most from the church in the year that he's been defying public health orders, came down with COVID and they shut down the church for 2 weeks. Statistically, apparently it would seem that church is better off than society as a whole in terms of contracting coronavirus. 35 days in jail, 2 weeks of which was decontamination. And according to Ezra Levant and Rebel Media, and it was mentioned yesterday during the live stream with Dave Rubin, they were actually releasing prisoners from that jail because of COVID while locking up pastors in that jail because of COVID violations. This is the state of Canada. And now we are actually not on the cusp of, we have breached that cliff of arresting a second pastor who dared hold religious services that were not in conformity with health guidelines. And that's it. I spent a good 15 minutes on the street last night, ranting and raving to my phone with the Viva on the Street update, going over everything. You know, the James Coates had his trial, actually the first 2 days of his trial in Alberta. And, you know, the first 2 days, things move at a snail's pace in court in general. But the first 2 days, the judge says, you know, we have a few questions to answer here. The two most important of which are going to be, were his constitutional rights violated, Pastor Coates? And if so, can it be justified in a free and democratic society? So while the judge renders a decision on that first question to determine the next step, the trial has been suspended to June 7th, I believe, to, you know, adjudicate on if there has been a constitutional violation. It's going to be up to the Crown to prove that it was a required, necessary violation. But this is the state of Canada now. A hermetically sealed country at this point. I made a joke a while back. It's only going to be a matter of time before we have a de-coronafied zone between Canada and the US. And I said it as a joke, tongue in cheek, you know, like a demilitarized zone between South Korea and North Korea. And we effectively have it. The government has deterred international travel to such a degree that we are effectively, Robert referred to something as a digital Berlin Wall last week. We effectively have the quarantine Berlin Wall. Nobody's going to leave this country and have to go to a quarantine facility for 2 weeks or 3 days upon coming back and pay, you know, $2,000 for the luxury. Nobody's going to travel. So you basically shut your country off. You deter anybody from visiting it. And at the same time, Bill C-10, everyone should get up in arms about this. At the same time, lo and behold, you have the government saying that they want to subject user-generated content on social media to the Broadcasting Act and the requirements under the Broadcasting Act that apply to, you know, traditional legacy media, radio and television. They effectively want to censor user-generated content on the only remaining platform for free speech for citizens. At the same time, they do everything else to shut this country down, lock off the borders, punish anybody who dares defy these rules, and punish them severely. Okay, that's the rant over. We are going to see if this is going to be, if Saturday night is going to be a terrible alternative to Sunday or not. But, okay, so standard disclaimers. No legal advice, people. Ordinary disclaimer. I would have said we're live on Rumble as well, but I can't seem to get there tonight because of the RTMP code does not seem to be working. What else? On the menu. Okay. What a week. What a week. And big stories that are as far as law stuff goes, earth-shattering stories. Sorry, I forgot the biggest one. I may not get to all the super chats. If I don't get to the super chats, don't be miffed. If you're going to be miffed, don't give the super chat. I don't like people feeling guilty. No, I don't like people feeling bad. It makes me feel guilty. Second thing, YouTube takes 30%. If that irks you, there's another way to support us on Viva Barnes Law. I'm not as good as Robert. VivaBarnesLaw.locals.com if you want to support us. There's a paywall there, yes, but all of our content is always going to be free on Rumble and it's always going to be free on YouTube. But there is a lot of good stuff for people who support us on VivaBarnesLaw.locals.com. Robert is a prolific publisher of hush-hush episodes, stuff that education, I mean, that you would otherwise, you know, go to university for, and it's free for me because we're partners in this. But anyways, so it's good there. What was the other disclaimer? That's pretty much it. Got a little pimple, if anybody can see that. I'm doing my best Claudia Schiffer impression. Okay, so that's it. So on the menu tonight, Chauvin juror. Well, first of all, Chauvin federal charges on civil rights violations, and the other three cops as well. You know, which is unsurprising news. We knew that was in the pipeline. Is that the word? We knew that was coming down. What we didn't know that was coming down was yet another juror on another high-profile politicized case with another social media footprint that is going to come back and bite them in the butt, but 10 times harder than the juror in the Roger Stone case. For anybody who might have forgotten about the Roger Stone case, we had that juror who ended up, you know, posting anti-Trump posts, you know, had apparently, you know, not been totally forthright on her jury questionnaire. The name doesn't matter. I remember the name, but it doesn't matter. In this case, in the Chauvin case, this juror, Brandon Mitchell, puts the Roger Stone juror to shame in terms of the potential, arguable, apparent, ostensible, objective, over-the-top juror bias. And I'm saying this tongue-in-cheek. It's absurd. We're going to get into it, and we're going to get into the details and the potential ramifications. Other on the menu is the white farmer class action lawsuit against Joe Biden and the subsidies that seem to distinguish between persons based purely on skin color as far as farmers goes. Who gets subsidies? My personal favorite subject of the week, the McCloskey case, is the new Flynn case. This is the judicial proverbial gift that keeps on giving, and I hate being cynical like that because it's giving at someone's expense. The McCloskeys, we all know the story. Kim Gardner, the circuit attorney for Missouri, is now facing an ethics complaint because apparently she had abused of her prosecutorial discretion and conduct in a prior case with the former governor or mayor, people, I forget which, governor of Missouri, Eric Greitens. And what she did is what she is alleged to have done is over the top, but absolutely explains what she did in the current case. Let me just see what else was on the menu. We've got the McDonald's soft serve ice cream. It was on, I forget his name now, the guy who does the conspiracy theories on YouTube, but the joke ones. Why the ice cream machines are always down at McDonald's. It's not a conspiracy. It's actual just business and bad franchise agreements, but we're going to get into that. CHOP lawsuit, the Summer of Love, which led to a lot of death, actually. Someone is suing for one of those incidents, and we're going to discuss that. And what else? Oh, the CDC is another good subject. The CDC nationwide moratorium on eviction under the pretext of preventing the spread of COVID was declared. What was the word? Was vacated. Was declared no. It was struck down by a federal judge in a well-reasoned but seemingly obvious decision. But so that's it. That's what we have on the menu. We're gonna have some other stuff. We'll see. I'm gonna make sure that Robert knows that we are here and live because I do not see his face. We're live, Robert. So that is on the menu now. Oh gosh, the Tamika, not the Tamika, the Kim Gardner ethics complaint is shocking, and we might start with that. And while we wait for Robert to come in, it was my video for today. It's so shocking, actually, because for what she is accused to have done in the McCloskeys, instructing an investigator to disassemble the firearm, to reassemble it so that it's functional, so they can press charges, weaponizing the indictment of the McCloskeys to fundraise off of it, to see this accusation of what she is accused to have done 3 years ago to Eric Greitens. I mean, I made the joke, success leaves clues, and so does corruption. It explains a lot. And it's an amazing thing. But what I find the most amazing about it is how the mainstream media that's reporting on it doesn't understand a thing. It is apparent on its face. They don't understand a thing of what they're reporting because I'm reading the articles and I'm reading them and just saying, I don't get anything of what they're saying, and I sort of understand the base level stuff. The whole funny thing, Tamika Hart was the juror in the Roger Stone case, and that was why it slipped. That was why it slipped out. It's the media does not understand what they're reporting, and in being unable to understand what they're reporting, they just repeat the same 30,000-foot overview, innocuous, useless, non-instructive there's an ethics complaint, and as a lawyer she could lose her license. They don't get into the ethics complaint. And now that I see Robert's here, we're going to get into this ethics complaint to kick off Saturday Night Live stream with Viva and Barnes. VivaBarnesLaw.locals.com. Robert, how you doing?
Good.
Oh man, okay. So look, I think a lot of people are not going to know that we're live Saturday because I think we spread it everywhere. I posted it on the community tab, Twitter. I missed Facebook, locals. So people tuning in tomorrow might just see this, but it'll be better than nothing. They can rewatch tomorrow, Sunday night. Happy Mother's Day in advance, everybody. Robert, Kim Gardner. Okay. What was I about to say? I know I had to look into this because when I was reading the media coverage, I didn't understand what they were talking about. They were accusing her of ethics complaint in the context of an investigation of then governor Eric Greitens. When I looked into it, everything came together. And you'll fill me in if I'm missing any of the details of the Greitens scandal. But Greitens was Navy SEAL, Republican, by the way, just for anybody who wants to, put confession through projection in work when Kim Gardner says that these are attacks on her from political enemies to remove her from office. It is exactly what she did with Eric Greitens, from what I can understand. Navy SEAL, Republican, first Jewish governor of Missouri. If that changed, I don't know why they mentioned that in Wikipedia, but apparently it's relevant. And he put in some plans and some policies that upset the unions. He put in some plans that, seemed to maybe I don't know, it was to restrict certain gifts, whatever. He came with policies that people didn't like. Shortly into his governorship, apparently he couldn't keep his pee-pee in his pants, had an affair, and the woman with whom he had an affair apparently accused him of blackmail. He took pictures of her and was threatening to, blackmail her if she mentioned his name, yada, yada. Kim Gardner investigates. She hires a private investigator for whatever the reason. You'll tell me if that's standard protocol. And basically, from what I understood, gave the investigator notes to basically say, this is what we need to find, bullet point notes, which she never disclosed to the defense, to the accused. She didn't communicate a bunch of documents. Her investigator ended up lying under oath. She ended up inducing her investigator to lie under oath to provide false answers to court. Failure to disclose exculpatory evidence or evidence that could mitigate the charges. The expert was ultimately indicted, 7 charges of felony perjury, among other things. And there was an investigation into her. And now 3 years later, this is the ethics complaint against her. And it really seems that, first of all, what she is saying people are doing to her is exactly what she did to Greitens. And what she did to Greitens is exactly what she did to the McCloskeys. What am I missing?
That basically sums it up. I mean, and have you detailed the ethics complaint that's now been filed against her in the Missouri Supreme Court?
So, I mean, I briefly went over it in the video. I mean, it's 73 pages, but the bottom line, I mean, I say it's repeating the same stuff over and over again. She induced witnesses to lie, which is unethical. She didn't stop them when they were providing false answers that she knew were false, which is unethical. She didn't disclose evidence, which is unethical. I mean, I think that's, but for some of the details as to who the players are, I mean, I think that's the essence of what anybody really needs to know.
Yeah, what's extraordinary about this is you have a county prosecutor, because that's who she is, the St. Louis County prosecutor, elected only by St. Louis, not elected by the state of Missouri, investigating the governor of the state. So that's the first anomaly. The second peculiarity that really shouldn't quite be within her jurisdiction outside of different circumstances than were present here. The second issue is that she is his strong political opponent, an adversary, and represents groups that are strongly politically opposed to him. So you have a conflict of interest at the core of the case. Then the third aspect is that you have, she was backed by George Soros. Soros has made a direct effort to influence America's criminal justice process by ways that if the European Commission on Human Rights wanted to apply consistency with its adjudication about corruption in criminal justice, like it wants to do to, say, Russia or other countries, then they should be outraged by what has been going on by Kim Gardner's office especially, but don't expect to be hearing from them anytime soon. And then fourth, the hiring of a private investigator, not just a private investigator, but from a completely different state. Went down and talked to him in Baton Rouge in Louisiana. What is she doing that? How did she meet this person? What are they aligned to do? And what she did was conspire with him to set up the governor of the state and get him removed using a criminal prosecution to politically embarrass him based on alleged personal conduct that ended up not being illegal conduct, as far as I can tell, in terms of where the evidence ultimately showed. And then when she got caught doing so, let him take the rap, the private investigator, because they always, rat out their own, and basically commissioned the perjury, suborned the perjury, supported the perjury, then covered up the perjury. This is extraordinary. This is not like if you looked at the ethics complaints against, say, Sidney Powell or Rudy Giuliani or Lynn Wood, They have nowhere near the factual evidence they have against Kim Gardner, and it is extraordinarily and exceptionally rare for an ethics board to ever do anything about corrupt prosecutors, particularly the politically protected corrupt prosecutors. But what it was, their conduct was so egregious and the evidence of it so convincing that they didn't have much of a choice without looking like political hacks. And that's why I think she's in serious trouble. You don't see 73-page ethics complaints filed in a state Supreme Court against an existing prosecutor with the kind of evidentiary detail present here unless subsequent consequences are coming.
And incidentally, for anybody who might be interested, apparently all the charges against Greitens, or I might be mispronouncing his name, apparently all the charges were dropped anyhow. And the KS who initially brought charges of extortion didn't have any of the pictures she alleged he took. Ultimately had no evidence of the charges. And so if exoneration is worth anything, all the charges were dropped.
But for those who don't know, he had to resign during the middle of all this because of the political effectiveness of it. So it was a hit job at work, but it gives you an idea. You know, when you look at the Spygate scandals and you look at the federal law enforcement authorities hiring private actors to go out and dig up a lot of the dirt and then report the dirt and pretend they're independent private actors when they're really government agents in disguise, you see a mini example of it, that this is a template. People often think, oh, you know, Barnes is just making this stuff up about government's up to this bad thing or that bad thing. This is a perfect example. Now the evidence is in and it's meaningfully not, can't be really disputed at this point. That's why she had to go the political route with confession through projection of accusing everyone else of what basically, this is what Soros prosecutors are trained to do. This is why he backed who he backed. These are prosecutors weaponizing the prosecutorial process for politicized purposes and willing to scratch all of the legal and ethical and professional rules that are supposed to limit and constrict their conduct.
It is. I mean, it's over the top. The detail. I mean, it's a 73-page ethics complaint. It goes through the excerpts of the transcripts. It goes through the specific answers, which were apparently, you know, the investigator said, I never took notes during that meeting. He took notes during the meeting. He never examined someone. He examined someone, like black on white stuff. And the knowledge of what it ended up looking like from the way it's described is that Kim Gardner drafted bullet points for the investigator to go out and now you know what you have to prove type thing. And go get this out of the witnesses, and didn't disclose any of this to the defense as she should have. I mean, I will see what the defense is. Based on her lawyer's public statement, it sounds weak and sounds like there is no defense, but everyone's saying Soros back, she's going to walk. What do you think is going to be the outcome of this?
There's two major problems. One is the evidence is just overwhelming. The second is the Missouri Supreme Court is not a liberal political Supreme Court. So that's her two big problems: the overwhelming nature of the evidence, and the Missouri Supreme Court not being a political backer of her. Greitens, by the way, I think he's interviewed me before. He was either on Newsmax or One American News Network, but he's now running for the U.S. Senate in Missouri. So he's going to be back in the political limelight himself and have some political power, potentially going down the road. So I think the politics align against Gardner. I think that she just got caught red-handed. But it tells you what, I mean, this looks like protocol. This looks like custom and practice. You know, that this was a way to set somebody up and to try to get away with it. And she just got caught, and she got caught so badly, the system of justice. I mean, this is going to contaminate every case in St. Louis potentially that she's involved with. So
some people were saying that in the comment section of the video from today. What implications could this have on every case that she's been involved in? Can people go ask for revisiting, re-examining of the evidence? What might have not been disclosed to an accused?
Absolutely. I mean, look at a lot of the cases when a cop gets caught systematically framing somebody, it sets up all their prior cases. In fact, there was a scene from City on a Hill, good show on, I think it's either Showtime or HBO, that's about Boston in the 80s and early 90s. And Kevin Bacon, the police officer, portrays a Fed, a very accurate portrayal, in my view, of a lot of your FBI guys. But they're trying to purge all the corruption in the Boston FBI office. And he makes clear that if they try to kick him out, he'll disclose everything that will contaminate all of their cases for 20 years. So that is commonly the case. It's commonly why they try to cover these cases up or try to get a quicker resolution. But Gardner just refuses. I mean, this is somebody who had to be removed from the state court because of her unethical conduct in the McCloskey prosecution.
Yeah, it's what she did in Greitens. I mean, it's virtually identical, mutatis mutandis, to what she did to the McCloskeys. You know, a weaponized prosecution to raise money off of it, instructing another investigator. This one, I guess, might have been a state investigator, not a private one, to basically fabricate the evidence. And then when they get caught, charge. You know, or I guess they charged them before, but then charge the accused with evidence tampering when it was they that tampered with the evidence. It's I mean, I say it couldn't have happened to a more deserving person. The only question is, on the one hand, you know, is anything going to happen, and what implication is it going to have on the one hand for the McCloskeys? Because I predict those charges have to get dropped sooner than later. This is just adding a little bit to that belief, but to the system in general in Missouri.
Oh, yeah, and to liberal prosecutors and Soros-backed prosecutors across the country, because this gives you an example of their template of how they operate, and it's deeply disturbing. It's highly unprofessional, highly unethical, not unique, unfortunately, to state or federal prosecutors or lawyers defending them, but so proven here that it's going to be very difficult for her to escape responsibility and accountability.
Now, Greitens, there was one thing I didn't get into. I didn't fully understand it, and I'm not sure that it was relevant. Greitens was ordered to repay some donations or something along those lines that the campaign had raised, and I didn't understand it as to whether or not it was a sign of any form of guilt in terms of any investigation that was brought against him during his tenure. So apparently, it was the second or first shortest governorship in Missouri. But are you familiar with any of the other issues that plagued his short tenure?
Usually, I mean, he was a target in my view, but that was kind of evident from the get-go. But a lot of Republicans were slow to the uptake as to what was going on, and and giving back donations is pretty commonplace. So, you know, anytime a controversy arises, somebody says, "Oh, I'll give back that person's donations." Happened in the Harvey Weinstein context, Steve Wynn context, a wide range of contexts. So that usually has no legal significance.
Oh, and by the way, the one thing I failed to mention, which was why maybe Eric Greitens was such a target of wrath. He's an apostate. He was Democrat, and he left the party and became a Republican. And apparently, if Dave Rubin's life experience shows anybody who's thinking of becoming an apostate one thing, it's that you become a very big target, because one does not just leave the party, so to speak.
Well, and you're talking about a young 44-year-old Navy SEAL, a state that, at least not these days, but used to be a swing state. He was considered a future presidential contender. So that's why they needed to take him out. And that's why he was so heavily and aggressively targeted. And, you know, it raises questions about the Matt Gaetz case and other cases. We're seeing a pattern of political targeting that is the kind, you know, another example maybe of confession through projection. Listen to what the U.S. State Department says about how Russia targets people. They may be talking about themselves more often than not.
Well, when Nancy Pelosi came out and explained the wrap-up smear in articulate detail, it was quite clear she's speaking from experience and probably not as the victim of it. But okay, well, that's it. I mean, we'll see. And the timeline for these ethics complaints, does she file a written response, and is that written response public, and is there a public hearing? How does it work? Do you know?
It depends. It depends. Each state has its own ethics procedure. So sometimes there's confidentiality, sometimes there's not. So it depends on the state's internal rules and how that process goes forward.
Okay. And I tell you, the one big problem, when Greitens, just by virtue of having an affair, it's a personal issue, but man, does it open the door for a bunch of stuff. And when you can't keep it in the pants, it just causes problems. And, you know, ordinarily these would be private problems, but politics is the dirtiest industry on earth. So when you make a mistake, adversaries pounce.
It's Berea's principle. You know, show me the man, I'll find you the crime. There's very few people that can survive a microscopic scrutiny, especially people that tend to seek political office. They tend to be of a certain personality type, be driven by certain instincts or goals or ideas or other things that, you know, their virtues often can be their vices. And that's what I find it just more problematic that this is just a method of operation in general, that this kind of weaponizing the political and prosecutorial and police process to target political adversaries is something that's supposed to be Soviet and Stasi in nature, not American in character, but it increasingly, unfortunately, is in some parts of the country.
Oh, sorry. John Law said, did he actually have the affair? Apparently, he actually had the affair. His wife and he made amends. They subsequently got divorced in 2020. But yeah, the affair was, people have affairs. And if I just brought up another question, another chat, didn't hurt Bill Clinton, but it hurt Bill Clinton. It just didn't end Bill Clinton, because the tolerance for infidelity is not an equal bar when it comes to both sides of the political aisle. Okay, well, I guess let's do the biggest one of the week. I mean, it's going to be the story that we're going to be probably covering time and time again over the next 2 years. The Chauvin, I mean, let's start with the easier aspect of this. Chauvin brought up on federal charges, civil rights, as the other three lawyers. I mean, no big surprise. It's just your point in this is that the double jeopardy system in America is broken when these same individuals can be charged under different sovereigns for crimes resulting from the same crime for which, at the very least, one of them has already been convicted.
Yeah, and my argument is they're not really different sovereigns. That's a legal fiction. The United States government is called the United States government. That means it's not a separate sovereign, in my view. It's a state-created entity to regulate each other. It's a compact between the states. And so the idea that a state government is a completely different sovereign from the federal government, as if it's France versus Belgium, just doesn't make sense to me. And so I find that fundamentally problematic. I don't think they ever should have adopted that principle. And if you continue to adopt that principle, you could subject people to 20 consecutive prosecutions and successive prosecutions, because you could keep going on, and you create more different divisions of a government and call it a different sovereign with overlapping authority. I mean, the point of a sovereign is that you don't have overlapping authority, right? This sovereign has this territory. This sovereign has a different territory. They don't both govern the same territory. That if you have this, in fact, there used to be a concept called, and still exists, called territorial jurisdiction. And there's also in personam jurisdiction, and jurisdiction because of you as an individual. And so here we have the state citizenship and United States citizenship are co-equal, because you're a citizen of the state, you're a citizen of the United States in general. And then the territory is the same. So the principles behind dual sovereignty don't apply in this context, in my view. When you have the same territory and same citizenship. So that's my problem. But that ship has sailed. I mean, the way I consider it is this is the judges let them get away with it. Doesn't mean the law lets them get away with it. It means the way the judges interpret the law let them get away with it. From 1895 to 1950, for over half a century, our judges in the South, state and federal, came up with every excuse in the world why not only most African Americans, but also many poor whites couldn't participate in their own governance. So, that's what they said the law was something that it wasn't. They lied about the law. And in my view, that's what's happening in the double jeopardy, dual sovereignty concept, because it just doesn't apply. But either way, that ship has sailed functionally. But a lot of people are still shocked. You'll find random people that'll be like, doesn't double jeopardy prohibit this? Oh, no, you didn't know our U.S. Supreme Court carved out a special exception that pretends that state governments are totally foreign to the federal government under double jeopardy principles and precepts. So, but in terms of the substance of the charges, the Department of Justice does have a policy not to do this in general. So they're only supposed to pursue it in unique circumstances, and they're not supposed to pursue it when the state convicts. I mean, the reason why their political excuse for this from the get-go was what happens when your local state government is corrupt and can't convict. Here they convicted Chauvin, and then they're still going to prosecute him again. It looks punitive. It's problematic from a political perspective, in my view. But putting that aside, go ahead.
No, I was going to say the burden. I mean, the burden of proof or the evidentiary burden. I'm thinking more for the other three cops on the civil rights violations. I mean, is it going to be easier to prove than the charges as they currently stand against the other three officers? And so, to some extent, it's not the second kick at the can, but it's a double kick at the can, and to try to get them on something that has maybe a lesser evidentiary burden to obtain a conviction.
Really, ultimately, it comes down to a lot of the same things. So the biggest difference is causation. They don't necessarily have to prove, it depends on how they approach the case, but they don't necessarily have to prove that it caused his death, that they can say something else. Usually that part relates to sentencing, but there's constitutional arguments about whether they may have to prove that at trial if they want the death penalty, for example, which appears what they're thinking about. Ironic from the Biden administration that claims to be opposed to the death penalty. The conflict within the Democratic Party is extraordinary right now in criminal justice, because the left says we shouldn't have this incarceral system, punitive-oriented criminal justice system at all. We should defund police. We should release everybody from prisons. And on an empirical basis, they have some good arguments that our incarceral system doesn't really work, at least not in the way it's sold to the American public is working, that it intends to harden criminals and create a criminal class, not deter it, especially as it relates to juveniles. But on the other hand, they want to weaponize the prosecutorial process to have the harshest punitive sentences for their political opponents or for politicized cases. And they can't seem to make up their mind. Well, are they Stalin, Soviet Stasi-style prosecutors, or do they really believe in opening up the prison jails? You can't have both of these principles put together at the same time. So we'll see how they work this out. But it's probably one of the most overt dual successive prosecutions in American history. They did this in Rodney King, but that was because they got acquitted in the state trial, not convicted. Now, the elements are a little bit, so there might be different elements on causation. Otherwise, everything else is almost the same. In fact, if anything, it can be tougher in certain contexts in the federal context because they have to prove willfulness. And that's a word that shows up a lot. And its interpretation can vary in the federal criminal justice process. But generally what it means is you have to know what you're doing is illegal. In the police officer context, it means you have to know what you're doing. In the criminal tax context, you have to know it actually violates the law. In other contexts, you have to know it violates the thing that the law prohibits. So in this context, you have to know not only that you exercised unreasonable force, but that you knew you were exercising unreasonable force. And so it was unclear in the Chauvin trial. Those instructions were vague in the Chauvin trial. They'll be more clear in the federal trial. So they don't necessarily have to prove certain aspects of causation or intent to cause serious risk to human life, unlike the state charges in part, depending on how you interpret felony murder in the Minnesota criminal system. But you do have to clearly show they knew they were violating reasonable force rules, that this was unreasonable force. And in the other officers, they had to have the aiding and abetting part is pretty comparable in the state and federal system. But to the degree the state instructions are vague, the federal system is clear. They have to know that this was unreasonable force. Now, they have an interesting interpretation. They're alleging deliberate indifference, which to show they have three different criminal counts. Some only apply. One only applies to Chauvin. Actually, two only apply to Chauvin, I think. No, one applies to Chauvin, two applies to both. They've also brought up Chauvin on separate charges for a prior incident that don't involve the other officers. But involving the other officers, it's aiding and abetting the exercise of deliberate, the excessive force. And they have a theory of aiding and abetting deliberate indifference or doing deliberate indifference, which is, they have an interesting interpretation here. And again, they contradict each other in terms of the state's position on different issues across this area of law. They're saying that it's deliberate indifference not to have given George Floyd medical aid. I've dealt with a lot of other cases where they say there's no duty to provide such aid. So, the government, including the state of Minnesota, including the feds. So it's a fascinating contradiction. Also, it's another, if you compare this case, they're prosecuting the other officers, including officers who said maybe we should flip them over, who just took their supervisor's guidance, while they're refusing to even name or further charge the officer who did the summary execution in the Ashley Babbitt case. This shows how overtly political the Biden Justice Department is.
Well, okay, we'll see. Do they get tried together, all four of them, or are they going to have separate trials on the federal charges?
The government wants to try all of the federal charges together. They will likely move for a severance. Two other differences are, it's whoever the federal judge is, and the federal judge may not be a Democratic ally, like you can pretty much guarantee a Hennepin County state court judge would be. Even though I thought Cahill went out of his way to be good, he still was aligned with the Democratic Party. No guarantee that will happen with the federal district court in Minnesota. You also have the 8th Circuit Court of Appeals that would be involved in the case. That's a federal court of appeals that now, while it always could have reviewed Chauvin's case in the state proceedings through a habeas petition, now it's guaranteed to review this case because some of the same issues will be implicated as in the state court proceedings, not the state law definitions, but the other aspects, and a different jury pool. This will not just be Hennepin County. So, that's why typically if you file a state civil rights case, in most jurisdictions, the city will remove the case to federal court, which is always ironic, right? The city of Milwaukee doesn't want Milwaukee City jurors on a civil rights case involving Milwaukee City misconduct. They want those suburbanites brought in, the people who fled the city in the first place. So who will be overly deferential to the police. And so they'll have a very different jury pool potentially. And then with all the controversy, which this might be a good bridge to, with what happened with the juror, I think the federal system is atrocious in jury selection, but there'll be major pressure on the federal system to have a different kind of jury selection process, issues of sequestration, and issues of how deep to go into jury selection, and venue issues that will all be pertinent because of what happened in the state proceedings.
All right, and JP says the courts have become purely political and are prosecuting their political rivals in the name of unity. We are one step closer to becoming the United Communist States of America. And we discussed this with the George Samueli last sidebar, talking about the Navalny trial in Russia being a farce of a trial. I have no doubt that people overseas, Eastern Europe, or in other countries are looking at the American system or the American prosecutorial system, maybe to a lesser degree Canadian laws, and saying probably the same things about us from over there. But let's get into the bigger controversy of the Chauvin case. The jury member who has now been outed, although it was only a matter of time, especially given how vocal and public he made himself. This is Brandon Mitchell, one of the jury members who immediately upon conviction, before sentencing, basically the day after the conviction, started doing the media rounds. A lot of people are hypothesizing that, I don't know if this individual gets paid for these media appearances, but there's hypothesizing that he is setting himself up for a lucrative book deal. We've seen it happen now from Amy Coney to Hunter Biden. Some people get book deals, other people get 6 months in the slammer. But he started doing the rounds, and in doing the rounds, he identified himself. He got his name out there, and very shortly, a very incriminating photograph, which was pre-trial in August of 2020, of this jury member at a Washington rally, which was for Martin Luther King Jr., but was a police brutality rally, and he was wearing a shirt. For anybody who has not yet seen the shirt, it said, get your knee off our neck. And it was a BLM shirt, and his was a BLM hat. And it became known now that this individual had attended a police brutality rally and seemingly had very favorable positions on BLM. I don't think anyone wears that prominent gear without supporting the message and the organization. The jury questionnaire, which we covered in a previous vlog, had specific questions on this. One of which was, other than protests in Minneapolis in support of George Floyd, have you attended any other police-related or police brutality rallies? To which he apparently responded, no. So that's the factual background now. It is not a hyperbolic or an exaggeration to say this is objectively a tainted juror to the point where it makes Runaway Jury, the movie, look less absurd. The question is now, what's going to be the outcome and what's going to be the consequences for him? Nelson made a motion for a new trial. Actually, I want to get into that, Robert. Nate Brody and someone on his channel during a live said something that was missing from Nelson's motion for a new trial were specific allegations on jury misconduct, on the jurors' misconduct, which I didn't pick up on. He alleged it in the beginning, but it wasn't enumerated in the body. Is that going to be a fatal deficiency? Can Nelson amend to add a specific allegation to that? How does that work?
He hasn't actually brought the motion. He's brought a notice that he's going to be bringing motions. So what it is within a certain time frame, you have to apprise the court of what issues you're going to raise. You don't have to provide the memorandum or the evidence for it at that stage, is my understanding in Minnesota. Some courts, they require that, but that's pretty uncommon because usually you need time if it's a post-trial related issue. So, and in Minnesota, they have an evidentiary hearing process that as to the juror. So what they will likely request is that evidentiary hearing be held, and Mitchell will have to come in and testify about a range of issues. And I suspect the judge will authorize that to occur. So that's not necessary procedurally because it wasn't the substance of the motion he really was bringing. It was a notice of, here's the motions we will be bringing, and here's the grounds. And he had multiple grounds beyond just the jury misconduct issue. And it mostly followed the issues we talked about as the grounds for either a new trial or an appeal. and that included a range of issues that happened at trial. The big ones being the venue determination, then the jury sequestration decision, the failure to instruct them not to review on social media, the refusal to allow a cross-examination of the witness who was taking the fifth, the drug dealer that was in Floyd's car. So the jury's never heard about that. Evidence concerning cumulation, because he really allowed cumulative evidence to happen. In other words, you're supposed to have one expert for a topic, not four. I think the prosecutors may have had 8 when you include some other people they had testify on their behalf as experts. That issue, allowing the prosecutors to lead the witnesses in certain contexts. Well, the biggest one I did not know about was the failure to inquire the jury after the Maxine Waters statements were made, and failure to sequester. But the big one I did not know about is I didn't know that all those sidebars the judge was keeping no transcript of. That's a bit of a problem. You're really not supposed to do that. I get why, because he didn't want things published, but you could seal that. So to not do that leaves an open door as to what really happened on a bunch of evidentiary rulings.
Are the sidebars, despite not having a transcript, are they recorded, or are they totally?
They were not. Apparently, that's what's alleged. It's that there's a bunch of sidebars with no notes, no recording, no transcription. That'd be a problem, potentially. Now, they find excuses to get around that, but they really don't like that because of the problems that it can raise. The defense lawyer can say, "Hey, I actually raised this objection," but I always tell lawyers, because there's some judges that will do that sort of thing. Always make sure you have an offer of proof on the record at the end of the day or anything else. Hey, I raised this. So we'll see. But he has unusually strong grounds, both for a new trial motion and for an appeal. And the question is whether any court will have the political will for it. I do believe that the federal prosecution gives the state courts a lot more leeway, because now they can let Chauvin walk and uphold the system and clarify criminal law and protect venue rights without Chauvin getting to walk, because he's already going to face federal prosecution. So to some degree, the feds rushing in the way they are is actually giving the state courts an excuse, political cover, to do what I consider the right thing legally. Now, in terms of his main argument is the juror misconduct is evidence of why the failure to sequester, why the failure to transfer venue, why the failure to expand the jury pool to be outside of Hennepin County, why the failure to inquire after the Maxine Waters statements are all consequential. He also has the jury instructions and raising questions about the law, of course, in his appeal. But so transitioning into the juror, what I think happened is this guy gave off the vibes of being an activist. I don't think he's driven by money or notoriety. And he made some statements that sounded like that right out of the gate. One, he confirmed what we said, that this was not a conscientious jury, that they probably would have convicted even quicker if they could have, and that there was one holdout. And they would have convicted in 10 minutes. That gives you how a sign of how thorough this jury was. An embarrassment to the rule of law. Those 11 jurors who sat on the jury and rushed to a conviction should be embarrassed and ashamed of their failure to uphold their constitutional duties. They decided to be the mob. They're no better than a lynch mob, because that's what they did. And
what the juror said, it does lead you to question what the juror, the activist juror, who's a BLM activist juror, might have said to the one other juror who seemed to be the lone holdout. And when you're talking about jury intimidation, and it was alleged in Nelson's motion, you can imagine if it's not overt, at the very least implicit jury intimidation from any juror who might, they may not know that this particular juror is a BLM activist or supporter, but they probably do. And you can imagine what type of intimidation that is having one of the very people who are out on the street violently protesting in the jury room. And I can only imagine what type of jury intimidation that would create for anybody who was, in any way thinking of defying the will of the others. I can't imagine anything more intimidating than that, actually.
What we talked about is what the press and the prosecutors were pushing in this case was to weaponize mob justice inside the jury room, to make 12 Angry Men a documentary, not a film. And that's, in my view, what this guy basically said, because what he also said was, he said things that sounded an awful lot like, I was an activist. I lied to get on the jury. I learned how to mask my emotions. I learned how to stay away from certain answers. I learned how to frame things in a certain way. To give you an example, this was the juror that I thought could be an acquittal juror based on what the media reports of what he said. So this guy was deliberately, he was the one who said he didn't think Chauvin had intent. He was lying across the board. He was lying to get on the jury, and he was encouraging other people to do so. Afterwards, he was saying, this is how you do it, folks. This is how you sneak onto the jury. This is how you tie that lynching rope well. And that's what he did. And then he kept lying about the rally, lied about how often he wore the T-shirt, lied about how much he remembered about it.
Yeah, he said it wasn't a what did he suggest that the rally was for? Voting rights, I believe.
Martin Luther King. He was just there to honor Martin Luther King. It had nothing to do with George Floyd's family being at the rally and speaking. That's relevant. And see, to give you an example, NBC was so embarrassing, they didn't even cover this. NBC News initially. ABC was even worse. They had a lawyer on from the Johnny Cochran law firm, which I'll give Johnny credit. He monetized his name all across the country. Everybody got to stick Cochran. You pay him some money, you get to stick, he had nothing to do with that law firm. For a certain amount of money, you could pretend to be part of Johnny Cochran's law firm effectively. I mean, that's clear when Johnny's dead and it's still the Cochran law firm. But this lawyer was on there, and she tried to say with a straight face, ABC News had this person on with a straight face saying, I don't see any sign of bias in that T-shirt. Get your knee off our necks. I mean, that's like saying, okay, yeah, we saw the guy in a Klan outfit and we have a photo of it, but he didn't have any bias concerning a black defendant. This is a crock. No,
it's preposterous to the point where it requires willful blindness from an audience to buy into it. So it's objective. The only question now is, what do you do with this particular fact? Nelson's made his motion. Incidentally, one question about the motion before I forget. Maurice Hall, he alleged that the confrontation provision of the Constitution was violated. The provision I read in the video was just, the right to a speedy trial, et cetera, a jury of your peers. The confrontation clause, I don't know what that means exactly, but I imagine it means the ability or the right to confront even a witness that is going to take the fifth, right? Is that what it means? Like, yeah, I can bring him up, even if all he does is say, I plead the fifth, he wants the jury to see the person pleading the fifth.
Correct. And you have a right to confront your accusers, which has been broadly interpreted to mean a right to confront any witness, a right to subpoena a witness, a right to ask questions and cross-examine the witness. It also, for example, the confrontation clause often limits the effect of the hearsay rule. So the hearsay rule has a constitutional component in these cases, in criminal cases. So that's what he was referencing. And that's...
So I was going to say, so the judge, Cahill, he basically said, we're not even going to compel this guy to appear as per the subpoena because all he's going to do is plead the fifth, so it's useless. Chauvin and Nelson are going to say, we want him up here. We want the jury to see this guy plead the fifth, if nothing else. Just from a practical point of view, when does a judge end an examination of a witness who's only pleading the fifth? Do they let it go on for 20 minutes, an hour, or 30 seconds?
I mean, usually just it depends. But it's where the Fifth Amendment right of the individual conflicts with the confrontation right. But generally, there is no violation of the Fifth Amendment right because the individual can assert it. And unlike involving the defendant, you can make negative inferences about asserting the fifth when that person's not the defendant in a criminal case. You can also make negative inferences about the Fifth Amendment in a civil case. So so that's why it's usually permitted should be, I should say, permitted. Courts often go back and forth on this. Famously, Mark Furman, the lead investigative officer who magically found all the evidence in the O.J. Simpson case, also took the fifth. That's who people are relying upon for believing the government's narrative about the O.J. Simpson case. But that will be for another later show.
All right. And now the question is, what happens? There's going to be a motion for a new trial. Cahill is going to hear it. Is there a time frame roughly, or does it take some time because they need to get the transcript of the trial?
Well, not only do they need a transcript of the trial, there'll probably be a juror misconduct hearing. And here's the interesting thing. There's only one juror. There's an alternate juror came out and talked, but only one regular juror, actual voting juror who has talked, and he ended up being corrupt. So what does that tell you about the possibility of 10 of the other 11? Well, what happened with them? So we still don't know. Remember, he's delayed that for 6 months, the publication of that. And there is one other addendum we should get into that Nick Rekieta asked about. which is whether the defense was thorough here and whether that will be a pretext of the prosecution, whether this was knowable information prior to his selection. But putting that aside, the public doesn't know about the other ones, and who knows what they'll find, because you see the utility of crowdsourcing, and it's why I generally oppose anonymous jurors. I understand why they did it in this case, and there were good arguments in this case, but it's risky because you get a Roger Stone problem. So Roger Stone, Roger Stone, there was no justification. There was no risk to these jurors in D.C., in my view.
Purely, I would say, it's purely political, no real risk of any sort of outrage from anything. Yeah, abusive. Well, here's the bigger question that a lot of people are asking. The jury questionnaire was under oath, so technically, if Brandon Mitchell unequivocally lied on the questionnaire, in theory, he can be brought up on charges of perjury.
So two things about that. One is, I think that they filled out the juror questionnaire before he went to that rally. That may be the case. That's part one, depending on the timing, but that's my understanding of the timing. So he may not have lied in the questionnaire, though I wonder a bit, because who shows up at multiple rallies with that, or a rally, but multiple appearances with that kind of T-shirt? He smells of an activist who created a fake story. It's a literal, people should watch, great film, good book, The Runaway Jury. Now, the movie makes it all about guns. The book was better. The book was about big tobacco, more realistic, more understandable. The idea that gun companies get away with stuff is just a bunch of gibberish. But that part of the narrative change by Hollywood I was not a fan of. But the rest of the film was still a pretty good film. And the book is actually a very good book. John Grisham describes the reality. People think that kind of jury selection, featured on the TV shows and other things, are not what happens in sophisticated cases. That's what sophisticated jury consultants do. Maybe not. I mean, not necessarily a Gene Hackman degree, right, where he's spying on people's, but in some big corporate cases, big government cases, you can't put that past them at all. Go back and read about the Jimmy Hoffa case. The Jimmy Hoffa jury tampering case arose out of Chattanooga, Tennessee, my hometown, and they went after Bookie Turner, great police commissioner in my hometown, because he found the feds were spying on the Hoffa jury. How did they find out about that so-called jury tampering in that case? People should put one and one together. Maybe somebody else was spying on that jury. So but that's another story for another day. So I think in terms of, but the problem he has is the judge specifically, his first question to every juror was, remember your answers. Is there anything now about those answers that are true or untrue? His argument might be, well, when I filled them out, they were true. And you didn't make clear whether anything had changed in the interim, though the judge made those kind of comments. I think it would be tricky to prosecute him for overt perjury, even though I think he was being deliberately deceptive. And I think there's no chance in the state of Minnesota or Hennepin County is going to prosecute a juror for leading the lynch mob. And nor will the feds. The feds could, that could be a potential violation of civil rights acting under color of state law. Apparently they're looking at that for the Ahmaud Arbery case. I'm not sure how that's supposed to work, but because usually this is supposed to be only government agents, but in the juror context, you could be acting under color of state law as a sworn juror, or as a sworn prospective juror. So there might be some civil right, but nobody's going to look at him because of the politics of the situation.
But the ultimate irony is going to be that if there is a new trial declared, I suspect some people are going to blame this guy, and some people who are, the very entities that have been in the streets and protesting are going to blame this guy, and it's going to be infighting that's not going to be pretty. Because my prediction, for what it's worth, I'm a lowly Canadian schnook who does not practice criminal law. They have to order a new trial, and if they don't, I don't know. It either comes now or on appeal. But I think Kale is going to order the new trial, and I think he's going to pin it on Mitchell as the catalyst or the straw that broke the camel's back for the one thing that went too far that is just undeniable now. Maxine Waters is one thing. I think it's very easy to pin it on Brandon Mitchell. I think the judge is going to do it, and then I think there's going to be a heck of a lot of infighting.
I think that they need more. So I think it's going to depend on a very effective cross-examination of the juror at the hearing. They have a specific court case the hearing is named after. And I think ideally they would get more jurors to talk to them. to confirm more information, more evidence, because otherwise it's very, very tough. Give you an example in the Snipes case. There, 9 jurors were for not guilty across the board. 3 jurors had lied to get onto the jury. We tried to out them as best we could. Judge shut us down. And they admitted in the jury room that that's what they had done. And now different lawyers handled that part of the proceeding, and they didn't follow my advice on that. And I think if they had, they would have had a better chance. But the judge found all the excuses in the world why he couldn't set aside the jury verdict, even though 3 jurors admitted they lied to get on the jury in order to convict them of something. And that's the only reason why 3 misdemeanor convictions even happened, is because they held out for those 3 misdemeanor convictions. Acquittals of all the felony, fraud, conspiracy, and tax evasion charges, and half the misdemeanors, but conviction on 3. That was a fraudulently obtained verdict that the court was glad to rubber stamp because they look to cover up cases like this. So I don't think Cahill's that kind of judge. But generally speaking, given the political weight around this case, though, again, Cahill now also has some immunity because the feds are prosecuting him anyway, along with the tax charges that are still pending against the guy, against Chauvin. In that context, he has more leeway, but I think he's going to want more compelling evidence. Now, in terms of what the defense lawyers should have done and whether that will be an excuse, generally speaking, if you have evidence before trial or before a verdict, and you don't raise it to the court and you only raise it after the fact, then you can be considered to have waived that right. But often that sort of doesn't always solve the problem from a prosecutorial perspective, because that raises issues of ineffective assistance of counsel if your lawyer's the one who made that choice. Now let's say you didn't know about it, but you should have known about it. In that context, that can also be grounds to excuse the misconduct that took place. And as to that, I don't think, well, here's what I think. I think a really good lawyer would have found it. But 95% of lawyers don't even look at jurors' social media. In the federal context, you usually never get the time. In a typical federal trial, like the reason we'll get into later, like comparing the Navalny case versus U.S. cases and so forth, the big difference is, the jury selection system in the United States. But in the United States, the federal criminal process has a much higher conviction rate than states in the 90s consistently. And my view is the main reason for that is states usually have much better jury selection than the feds do, because the feds usually give you 30 minutes to an hour to pick a jury from the time you meet them. You even get to know their name. You're supposed to look up social media in an hour. So that's part one. But in this case, they had plenty of time to research them. Now, they used to threaten lawyers that if they tried to research jurors' social media,
it would be unethical to interfere or influence a witness.
You're contacting
a jury member. Sorry.
Exactly. And so that ship has now sailed, in my view, with the Roger Stone case. Once the judge said, it's your duty to do so, I'm going to be using that anytime anybody starts to raise a question. Now, I have for a dozen plus years used outside third-party vendors to get me every piece of information on a potential juror that's possible. And find every way conceivable to try to make sure the jury process is more thorough and expansive. But it's an uphill war in the federal court system, and not so much in the state courts.
It doesn't make sense that it wouldn't actually be required, not just potentially unethical and forbidden. It doesn't. Well, they're answering under oath. They're going to be assuming something of a quasi-public function. Mm-hmm. It doesn't make sense that you would not be able to vet in a meaningful sense the questionnaire and their statements under oath. So it's foreign to me, but it's foreign to me. I've been familiarized, through our live streams. It's a bizarre idea that you just take them at their word for it. You have 30 minutes to find out, maybe an hour, depending on if you're lucky. And if you find out something after the fact, well, too bad, so sad, it's too late.
Well, to give an example, in most federal cases, the lawyer doesn't get to ask a single question of the potential jury. Only the judge asks the questions. And the judge asks leading questions. You agree that you can be fair and neutral, right? You agree that you can set aside any possession you have and make it all those bogus questions that are utterly useless, that the only people that will answer honestly are the ones that would actually be good jurors. Bad jurors will say, I can absolutely be fair and impartial. And all human beings believe this. The ones that are aware of their biases will be the best jurors. But because they'll admit their biases, they'll be excluded from the jury process. It's insane. So only in state courts usually do you get to ask a single question to the jury. And in federal courts, I've had judges threaten to put me in jail if I ask questions of the jury that they haven't pre-approved. I mean, that's how bad it is. The reason is this. They know that your average jury will be a pro-government jury. And consequently, their goal is to use the jury process to validate and vindicate the conviction, not because they want an actual truth-seeking, moral, justice-seeking jury. That's the last thing they want. They don't want any Ed Snowdens wandering around that jury. They want jurors that will say yes. They want a jury like the Japanese system, where the Japanese #1 in the world in conviction rate, over 99% every single year. Why? It's because they're very deferential to authority by their culture. And they know that's the reflexive jury. So they know the less questions you get as a defense lawyer, the more likely you're going to have a pro-government jury sitting there. And so now, but in this case, it appeared he gave them broad range to ask questions, did a written questionnaire. They got news and information about the jurors months in advance. So I believe a good lawyer should have done deep research on this guy. But to give an example, this wasn't on his social media. Somebody probably didn't do the search because Facebook's tagging function is what uncovered this guy. This guy's uncle bought into, how Facebook tags and ask you to put, who's in this photo? And the uncle was like, my nephew's in this photo.
You don't need Secret Service. You don't need spies when you have social media and all of their tagging mechanisms. There's a reason for it, and there's a very, very big risk to it. This is one of them. Yeah, it was his uncle that posted it, tagged him, and it was discovered afterwards. But
by a bunch of social media independent detectives. That's why they do great work. And published and broadcast once it was confirmed by Jack Posobiec. And so that kind of makes the defense lawyers look bad, but in the defense of defense lawyers, 95% of them don't even do anything with social media. To give you an example, this was before social media was really big. In the Snipes trial, we had like massive books because we were going to get the juror information late. We knew that. So I wanted every person who lived in the entire area and as much information on everybody. And, what people don't realize is these days with data, even without social media, you have 300, 400 pieces of information on most people. Every subscription you've ever made, every donation you've ever made, every place you've ever been, intel's out there. And so I remember we were going through them and we were picking, different jurors, and I was highlighting different facts that were key. The other defense lawyers, because there were other defendants in that case, were shocked. They're like, where does this come from? Gives you an idea of how abnormal this is to defense lawyers. Still is. And Snipes made the joke to one of the defense lawyers. He goes, wait till we see what we have on you, which was kind of ironic because that lawyer ended up, well, that's another story. pretending to be me and going to certain clubs. So people were saying, I heard Barnes was at this club. I was working the whole time. And it turned out this guy, because my name had been in the press, thought it would get him more attention from certain companions at those clubs. Let's put it that way. It's all these rumors about me were spreading around. It had nothing to do with it.
It's probably the ultimate plot twist. You were at those clubs, Robert.
My evil twin, Paul. But I was nowhere near any of those places. Man, that case was brutal. Only got stuff the night before. But that's abnormal. So it's hard to say that that's unethical or professional malpractice for him not to have found it when this whole thing is foreign to most defense lawyers. Now, I hope that defense lawyers learn from it and realize you need to have good pollsters. You need to have good focus groups. You need to have good mock trials. Now, I understand that some they don't have the resources, so I get that. But if you have any, and here's the other thing: defense lawyers spend all their money. I told on Eric Hunley's Unstructured podcast, unstructured.locals.com. You can find him there too. That in the process. Oh man, I just completely forgot where I was at.
Discovering on social media using proper pollsters and researchers.
Yes. In terms of that, if I had a choice as a defendant, and let's say I only had $25,000, and I had a choice between hiring a lawyer for $25,000 and spending the whole $25,000 on a jury selection person, I'd spend it all on the jury selection person. That's going to make a bigger impact on your case than the entire trial. Trial is 90% theater, 10% persuasion. Most of the time you're there in the theater to persuade the people to give arguments to the people that are already with you in the jury room. That's it. But if you don't have enough of them, it doesn't matter anything you do. But lawyers spend all their time where I'm going to cross-examine this person, and then I'll get the direct examination and the day-to-day drama, and then I'll get the jury instructions. And none of that matters 90% of the time. It's all about who your audience is. If you haven't won with that, you're not going to win the trial. So for ordinary people, think of it this way. Let's say if you're Trump and you're picking a jury. If you pick a bunch of Democrats, do you think they'll ever rule in favor of Trump? That's the way human beings are. even about cases they've never heard about before they walk in. And in this case, they'd all heard about it before they walked in.
Well, I mean, this was just, it was over the top in terms of what it was. The idea that it could have been discovered beforehand. I mean, to some extent, that's like saying, if I lie under oath, but you could have proven that I was lying, then it's your fault. I don't know how far that goes, but again, my experience is limited.
That's often what the government and the judges argue, by the way. They say, you should have figured out the government was lying to you. It's on you. It's amazing the excuses they'll go to. But I agree that Cahill should grant a new trial. I think they need to develop more evidence from more jurors and more evidence about this juror in order to do so. Now, my guess is this guy wasn't hiding that much. Yeah, he's appearing on podcasts before the trial started. He was appearing at the rally, allowing photographs to be posted on social media. Wasn't making sure those were removed beforehand. Hadn't really done a search of his own name with photo images beforehand. So I think all of that's going to raise some trouble for him. But I do think defense lawyers should learn you need much better jury selection. You need more involvement of pollsters and data professionals, because there's a wide range of data and information, because you don't want to be that lawyer that missed the glaring problem with one of your potential jurors.
Nelson will always have an excuse. He was the David versus the Goliath, didn't have the team, he was the one-man show. But I mean, and in a way, it might be better that it happens this way than before, because now you have a better argument. What would you do if you discovered a jury member was tainted in the process? You'd make a motion to disqualify a juror?
Yeah, immediately. Okay. Yeah, in fact, you're obligated to do so, or you waive it.
All right. Now, on the issue of potentially racial issues, let's get into the white farmer class action lawsuit against Biden for discrimination. Now, Robert, it was a 255-page motion. I didn't read it, so I just up as much as I could without actually reading the motion. I skimmed through it briefly. Bottom line, from what I understand, is that as part of the COVID relief package, the government is giving certain benefits to farmers, among other people, but we're focusing only on the farmers. Those benefits involve loan forgiveness and basically an additional, cash injection, an additional amount given to the farmers, except only based on ethnicity, in that they're targeting racial minority farmers for this benefit and not all farmers. And so one farmer in particular out of Texas filed a class action lawsuit on the basis that this is just outright discrimination, giving grants to farmers, but only non-white farmers. I mean, I think that's the essence of the lawsuit, right? And that's the essence of the program that is at issue here?
Yes. So the plaintiff happens to also be the Secretary of Agriculture of Texas, but he's only suing in his individual name. And this is one of the first suits brought by the America First legal group, which was founded by Stephen Miller, supported by Mark Meadows and others. And people have asked me about it. I said, I don't know. I said I'm going to wait and see, watch and see approach as to how effective they'll be. But I think this was a solid first effort out of the gate, because what happened was, as part of COVID relief, Biden limited COVID relief for farmers to only those who are, quote, socially disadvantaged. And then they turned around and defined socially disadvantaged as from a group that has experienced racial discrimination, but then went further and said there's no group of white people that has ever been subject to social discrimination. But then we're a little bit unclear on what percentage ethnicity you need it to be. So, for example, this plaintiff has, African-American ancestors, has multiple racial ancestors. They make the point that there's a wide range of groups that may have white skin who have had a history of discrimination against them: Italians, Irish, Jews, a whole bunch of people.
That's what Miller said. He said he's part Irish, and that the Irish have faced discrimination. So therefore, and that was one of the arguments I read. Correct,
especially to be race neutral. The problem with this, the problem is with the laws. They're trying to get around how the law is written itself, though not entirely. They say the law should just be enjoined, period. But definitely the particular application that Biden has chosen to make here. Basically, it's a big sign that says white farmers need not apply. Even if, and especially in this context, because this is about COVID relief, for where farmers were hurt, not really because of COVID, but hurt because of all the lockdowns that the governments required or compelled, as where COVID was the excuse or pretext for that. So they deprive farmers of their market, sometimes deprive farmers the ability to even go out and farm, sometimes forced farmers to destroy products. So in that context, why should race be a governing basis by which COVID relief is issued? So that's problem number one. Problem number two is, of course, constitutionally, the federal government is prohibited from racial discrimination and racial prejudice. And I think that they have a very sound, very strong constitutional legal claim. They filed the suit in the Western District of Texas, I believe the Austin division, but there's a lot of conservative judges on the federal side in the Western District of Texas in Austin. And so I think that there's good grounds for it. So I think the suit is the right suit legally, constitutionally. It's just whether are we going to allow open, overt racial discrimination and by the federal government in distribution of federal resources for something that doesn't relate at all to racial prejudice or racial discrimination.
So that was the question I was going to ask, and forgive it, it's going to be a totally ignorant question, but how did the state or how did the federal get around affirmative action? I mean, that I guess the idea is that it's responding to a specific racial issue and therefore it can be justified, whereas subsidies to farmers is not.
Well, affirmative action has always been controversial, and the Supreme Court has limited its ability to happen. At one time, they approved a limited version of it. Then they came back and suggested, no version of it is okay. And it's sort of been an open question. And the big one that was going to go up until the Biden administration interfered and prevented it from going to the U.S. Supreme Court was the open discrimination by Harvard University against Asian Americans. And so, in my view, it's all unconstitutional and all illegal. But the courts have turned a blind eye to aspects of it. And so we'll see, are they willing to be overt? Because this is the most overt of them all. This isn't about, because of a legacy of disparate impact, we're going to provide a particular advantage to a particular group, like, say, in loan programs. This is taking it a whole new level and saying we'll just racially discriminate whenever we want, wherever we want, however we want in federal programs, even when the program has no relationship to racial issues.
I watched Mark Lamont Hill. Now, I don't know if he's as well known. I don't know if he's well known. I saw his YouTube channel and watched his take on this particular issue, and I was thoroughly unimpressed with the reasoning of his take, which was that, white people, this is paraphrasing, but he said white people only get up in arms when they get ignored or when they say, hey, I'm white and I want something that is a privilege. But what I understood from what he said is that he said it was like 25% of farmers were black, and I understood it as only being like 1.5% of farmers that are black, or that would be the object of this subsidy in the first place. So, first question: which stat is right? It's 1.5% of American farmers are black, or is it a bigger number?
To my knowledge, it's very low. So unless he's making some historical reference, like from a century ago, but I mean I've not. Everything I've heard is that there's not many black farmers today.
Okay, and now the second question then is going to be, I guess, from the
now, he might mean 25% all groups, like you include Latinos and Asian Americans, because I think they are also included in this group.
Okay, the second question then is going to be, would it be financially feasible to give this to all farmers? I mean, is it even economically feasible to offer this program to all farmers? And is this a way of, I want to say, scoring some virtue points by offering something that's ultimately going to only touch a minimal amount of people, farmers in the first place, because of the sheer numbers, whereas it would be impractical and impossible to offer on a broad scale to all farmers?
Maybe that's part of their excuse for why they're giving the relief that they are. But I mean, that it doesn't make a lot of sense, because I mean, it's not like they're holding back on the checkbook these days. So I mean, they're printing cash. That meme with the Federal Reserve guy going, the machine goes burr 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 with the dollar bills just flying. That's what they're doing. So, it would be peculiar to say, well, we have plenty of money, except not the white farmers. So they're spending everywhere else.
I know it's, I couldn't believe it, but I just have to take for granted there's something I'm not getting about the program, but it doesn't seem that there's anything.
It's meant to be overt. I mean, it's meant to be the predicate of reparations. It's meant to say we can openly and overtly racially discriminate, and they're just doing so in a space they think they can get away with it. And they're hoping the courts greenlight it so they can expand it and extend the principle just broadly. Start saying we want, basically, they just want to say we would like to give money only to Democratic voting groups. I mean, how long before they just do that? They say if you can prove you're a Democrat, a registered Democrat, then you get federal money, and if you're not, you don't get anything. Just one step away from it.
Okay, so we'll see. Time frame going forward. First of all, it's a class action lawsuit out of Texas. People have to opt in if they want to do it. What's the rule in Texas?
Well, first there'll be a motion to dismiss, and it'll be whether they survive the motion to dismiss. And then later through discovery, they get to the class certification stage. That's much farther down the road. So I think it will be the big question up front will be whether or not they survive a motion to dismiss. If they do that, then they're in the game.
Okay, now let's move on to another questionable federal policy. Let's do the CDC eviction moratorium being struck down. General context for anybody who doesn't know, the CDC, at one point, under Trump, once they declared the pandemic a pandemic, they declared a moratorium on evictions for properties that were receiving federal subsidies, federal assistance. It was for, I think it was a finite period of time, 4 months or 6 months. At one point, after the moratorium expired, the CDC, and I don't know how they do this, you're going to have to explain how they can even have the authority to do this in the first place, issue a nationwide moratorium on all evictions, on all properties, regardless of whether or not they receive federal subsidies. And they extended it. There was an issue that I think you might want to clarify, that Congress, it was an argument raised in the motion, Congress ratified the moratorium, which they argued was some sort of tacit congressional recognition, validating of the moratorium. Just on that one particular question, could you explain what the argument was, how Congress ratified it, and under what context they ratified it?
So, I mean, because at courts, whether they had the authority to do so under the laws that existed. So there's a secondary argument about whether they have constitutional authority to do so under the Commerce Clause. And that second argument doesn't matter what Congress wanted to do, because if they don't have Commerce Clause constitutional authority, Congress didn't have the authority either. But that argument only applied to the argument about whether Congress gave them this authority through the statutes and regulations. And this is all because of the Chevron deference doctrine, where they allow the administrative branch of government, which isn't supposed to really exist. It's supposed to be just the executive branch of government enforcing laws, not interpreting them, not creating them. But that's what effectively the courts have over time allowed through the in the post New Deal era. After the last time, a Democratic president threatened to stack the court, the Supreme Court started deferring to this administrative branch. But so that's a separate constitutional issue about undue deference in the first place, and why is the executive branch passing laws? But putting that aside, the question is whether or not Congress gave them this authority. Arguing that they got that authority retroactively by Congress saying, yeah, we approve of what you did, that doesn't give them the authority. They needed the authority before they took action, and then the authority needed to be by explicit statutory legislation giving them that authority, and that they never got. And so I get that,
Oh, no, I was going to say, so their argument, the CDC's argument, setting aside whether or not Congress tacitly ratified their moratorium, their argument was that under I forget the name of the Health Act, that they had the authority to declare nationwide moratorium on evictions because it would prevent the spread of COVID, because it would be ancillary or incidental or included in their other powers to stop the spread of disease, which they were, relying on the regulation, which included fumigating, killing animals, et cetera, and isolating people who are infected. And they said this law gave us the power to declare a moratorium on evictions because to kick people out or to evict would increase the spread of the virus, et cetera. And the judge basically said no. And there wasn't really much discussion about it. It was just a question of this having to go to court to actually have a judge say no. On the one hand, what do you think of the judgment? Does it go to appeal? And then I got a second question, or another question on a separate issue after that.
When we talked about this back in September, what I said is it was good for Trump, but it was clearly illegal. But it was good for Trump because it would likely not be declared illegal until after the election, which is what happened. So Trump supported this implicitly. He was the one who triggered the process by asking the CDC to look at whether they had that authority. Everybody who looked at it said, no, they don't have that authority. Because basically it was taking a principle of, hey, going in and fumigating a property somehow gives you the authority to regulate landlords, tenants' rental agreements and eviction protocols and foreclosure policies. That was ludicrous. But it tells you where the government is these days. On the loosest, thinnest pretext, they're saying they have this broad, expansive power. And as the judge noted, not only is that not explicitly in the statute, they'd never claimed this for the decades this law existed. They suddenly found it overnight. They're like, oh, look at this magical power I have. And he's like, no. Everybody kind of knew this. And really, the courts just slow played it to allow the political benefit of it to play out before stepping in and saying, nah, this was actually always illegal. The court decision is clearly right on the law, in my view. I don't see it being overturned.
And now, so that was one other question that I had is, Trump had queried with the CDC to look into this authority. Did some take that as a tacit request from Trump to declare that they had the authority, or was it
he made public statements to that effect. So there was no doubt about what answer he wanted them to come back with.
Okay, now the question is this. People were asking, I think the answer is a big fat no. Landlords who were unable to evict tenants who were not paying rent, they are not going to collect that rent anymore now. Now they can go ahead and evict or, try to recoup rent. Does anyone have a recourse? Do any landlords have recourse against the CDC for this order, which was now declared unlawful? Not
likely is the short answer.
And that is what is called sucking on a lemon in law. So, okay.
Meet the federal government. Federal government's even worse at the state government level. This may be a good transition into the Chaz chop suits.
Let's do it.
Because the same Democratic politicians who hate qualified immunity for cops love qualified immunity when it comes to them, because the suits continue, as we predicted, the suits continue to multiply around Chaz and Chop, whichever definition, the Capitol Hill Autonomous Zone or the Capitol Hill Occupied, whatever the name is, I think
they're going with Chop now, not Chaz. But
all right, so we'll go with Chop. That's even worse name. It makes me think of cutting up a steak. But I think of a big butcher knife, probably because I think there's a Chop Steakhouse that has a big butcher knife up front. But
there was the show. It was called Chopped. It was the chef show where they cut chefs in a reality type show called Chopped. But good show.
Okay, maybe that's where I got it from. But either way, because of the dumb statements made by the mayor is what created this. Now, as a whole, they have to get past qualified immunity. But as people have been doing the analysis, as Turley did this analysis, he said it's because we have all these crazy judicial doctrines. My own view is there shouldn't be any qualified immunity for anybody. We shouldn't just say, let's take it away from police. Let's take it away from politicians. In fact, if anything, they should be taken away from them first. But in this context, what the city needs to assert and what the plaintiffs have to overcome is whether or not the city knew that what they were doing was violating people's constitutional rights. And the hard part is there's and here's where a lot of courts come in. Courts say, if you're real creative at violating people's constitutional rights, we'll say there was no precedent for you to know that was a violation of your constitutional rights. Ha, 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 thrown out of court. So that's what the defense, the same people who demand no qualified immunity for cops are going to be demanding qualified immunity for themselves in this continued two-tier justice system that we have. And that's what Seattle will be asserting. The problem for Seattle will be all the stupid statements made by the mayor, who called it who basically invited it. It's an attractive nuisance, which I always think of William Shatner's character from Boston Legal, who described his particular grabbing activity as being because of an attractive nuisance. He was like, she was an attractive nuisance. But an attractive nuisance is like you put a playground in your backyard that's open to kids, and there's a defect in it that could hurt them. They like, oh, look at that cool playground. They go in and they hurt themselves. So things like that. She basically created an attractive nuisance and knew she was doing so by saying that this is the summer of love. This is just a block party. Come on down. Everybody welcome. Trump is an idiot for saying anything bad about it. Then, of course, people ended up dead. And the people that ended up dead, now the estates are suing. Not only are the businesses already suing, now you have everybody that got harmed in it suing. The city of Seattle could be bankrupted by the end of this unless they survive on immunity.
Well, and incidentally, the family on behalf of whom this particular one is taken, was a 16-year-old kid with special needs, from what I understand, who was shot, and police and paramedics could not get in because they weren't going in. But now it could bankrupt the city, Robert. But the cynic in me says they're going to set one precedent, which says that you can't sue, and it's going to end all the other lawsuits and the lawsuits for taking and for whatever. They're going to set one precedent, and everyone's going to be deprived of remedy. They can't bankrupt the city as a pure matter of fact to compensate these people for wrongs. First of all, is that a wrong prediction, or is that
Oh, I mean, they could always bankrupt the city. Many cities have gone through bankruptcy proceedings, and they have various sources of resources and assets and property and tax revenue rights, etc. But and I think that often people don't like the suits because of what the commentator's talking about. But in my view, they're very politically effective. So what happens when cities have to pay out big settlements? It usually changes their procedures, changes their guidelines, improves their policies, and politicians usually pay as much of a price as anyone else. So I get that the taxpayers are the ones writing the check. The greatest impact ends up being on the politicians who caused the problem in the first place. So there's if you pay attention to a lot, I've been doing these for over 20 years. It always works a positive effect on the city when they have to write a big check. They change the rules, they change the policies, they change the guidelines, and the politicians that were part of it usually pay a political price. So it may not seem like it's impactful, but it usually is. And often it's the only thing that's impactful. Sometimes just filing the suit can trigger a good response. So it's good that there's, the importance of setting the precedent here is so it doesn't happen again. No more of these creating autonomous zones for Antifa. We're seeing cases in Texas, cases in Portland, where Antifa's out directing traffic, creating problems.
You have to wonder what people in other countries, and I'm only thinking Russia by comparison, just because of the amount of focus the West has put on Russia in terms of demonizing it. You got to wonder what people in Russia are thinking and saying, watching what's going on if they even see it, just because the media doesn't cover it. Ian Hall says qualified immunity is a joke, but a basis for term limits and other restrictions for all state or federal doesn't matter. Yeah, the qualified immunity is it's the double-edged political sword. It should not exist.
It's invented doctrine. It's invented, not real. It's invented by judges in robes to protect their political pals. It's not rooted in our Constitution.
But am I wrong in thinking I thought there was a particular case that said that the police have no affirmative duty to respond to certain?
That's absolutely true. I mean, I've had cases where kids have drowned in state pools, where people they're mentally ill, cut off their genitalia, and they were institutionalized to prevent that. And the judges said, no deliberate indifference there. So, I mean, that gives you an idea. I mean, it all depends on the courts go out of their way to cover up for politicians, but they're very erratic when they do so, like we're seeing in the Chauvin cases.
All right. Do we want to get into the Triller lawsuit real quick? The Triller one.
Yeah. Well, there's two. I have the ones I have left are Twiller, McDonald's, a little bit on the Navalny case, and then Bobby Kennedy's children's health defense against Facebook.
Okay, well let's do Triller real quick, because I think we're going to. Incidentally, if anyone has not seen it or doesn't know about it, go watch Nick Rekieta's video on it. Don't need to know more than that. Nick destroys it. Bottom line, Triller is the company that owned the rights to the Jake Paul. I forget who he fought. UFC. The fight.
Ben Askren, yeah. Ben Askren, yes. They own the rights to the streaming of that fight, and apparently a bunch of people stole it, but strangely in their lawsuit failed to identify a single case of them actually stealing it.
Well, so the lawsuit as drafted, and I mean, I think I would like to think I would have picked it up on my own, but you never know. Nick points it out. The lawsuit goes through parties, jurisdiction, and it alleges no facts before getting into the counts, which you're basically alleging law with no supporting fact, which is a non-starter for any lawsuit in any jurisdiction. You can't just allege conclusions without the supporting facts to justify them. But the bottom line is they don't know who stole the fight, if anybody. They don't know. They didn't identify any facts that would allow them to sue any one of the individuals, but they used the lawsuit as a pressure tactic to coerce anybody who might have streamed or seen the fight illegally to go to a website and remedy their illegal conduct by paying $50 retroactively for the fight, and
self-incriminating themselves in the process.
They're focusing on H3H3's admission in one of the podcasts that they illegally pirated the stream, but from a lawsuit perspective, it's defective on its face. Apparently, the judge was raising certain issues.
They alleged count 6, conspiracy. And as Nick pointed out, and for everybody out there, there's no such thing as a claim for conspiracy. There could be a claim for, say, breach of contract. And the means by which the breach of contract occurred may be a conspiracy or aiding and abetting or something of that nature. But conspiracy by itself is not a separate cause of action. It has to be conspiracy to violate this, conspiracy to violate this. Conspiracy is not a separate tort. And it's a sign of elemental failure of lawyers when a judge sees, you even put it in the top, count 6, just conspiracy. The judge was like, okay, this is idiotic. I'm going to issue a sua sponte order. What is this crap? And they're already on the wrong foot with the judge without even an answer being filed or serving the suit yet. So that gives you an idea for how clueless this group of lawyers is.
Yeah, I mean, you gotta wonder what they're doing. I mean, you gotta wonder what
they're trying to scare every mom and pop and every little kid at home into ratting themselves out and confessing to a crime against their self-interest for monies they would never likely be able to get anyway. That's what their real goal is. Throw in some high-profile people, terrorize a bunch of kids who are like, oh man, I streamed that illegally, to going in and volunteering incriminatory information against themselves, and in the process paying over money that isn't even a settlement of their civil case because it's not even subject to a pre-agreed civil settlement in the first place. As all of which Nick detailed. So I mean, it's a crock. It's an intimidation tactic. It's a misuse and abuse of the legal system. So it's problematic. Now that doesn't mean they don't ultimately have a claim. If somebody went out and actually stole the material, well, they have a claim for, but not $10 million. It would be whatever the value of the stream is. Sometimes a multiplier involved. But the idea that, I mean, this was just a terror tactic by using legal bullying to try to scare a bunch of legally unaware, unfamiliar people, uneducated people into confessing a crime against their self-interest.
No, absolutely. Now, a bearded Bronco. Oh man, your avatar would have made so much more sense if I read your name first, because I was trying to figure out what I was looking at there. Ethan Klein stole it, admitted to 3-7. Hey, yeah, I saw Ethan admit that he pirated it. That's worth what it's worth. But you go to Drama Alert with Keemstar, who, Ethan Klein might go to jail for, pay $1 million. I was watching other non-lawyer YouTubers break this down. It was humorous in a sad way, where people are like, Ethan Klein he might have to pay $150,000 penalty per incident. And if people watched it off of his channel, that could be millions. I think the idea of getting a maximum sentence for streaming a fight, it's outlandish to the point of, lacking credibility. The fact that Ethan admitted it, whatever that's worth, whatever that means, it's a minor amount.
If they had just sued him, not asserted crazy amounts, that would show sincerity in their effort to try to discourage and deter other people from doing so. But that isn't what they did. They sued a bunch of people. They don't have the facts that ground their suit in fact, and admit so by not having a statement of fact section separately identified for the court, and allege claims that are not causes of action in the first place. That's why, from a legal perspective, this suit was a joke. And many of the people who are overreacting to it on YouTube or trying to parlay it were misreading and misinterpreting it completely. Doesn't mean that everybody involved gets to take a walk, but it's nothing like the nonsense. This suit is not a suit to take seriously at this stage of the case.
Well, I'm glad I skipped over it, but once I saw Nick's, I mean, like I said, I have nothing new to add to that. It's perfection of a vlog. Okay, another quick one. The McDonald's viral video. Shane Dawson is the guy's name. Thank goodness I got it. So apparently, it has become a meme. McDonald's ice cream is always broken. Their ice cream machines, they never serve ice cream. It's become an internet, not lark, whatever, a meme. And there was an in-depth expose as to why it happens. And it's really not that controversial at the end of the day. It's that you have these franchise agreements with all of these independently owned McDonald's franchises. They have to use a certain machine for the ice cream. The machine sucks. It comes exclusively from one company. That company has the exclusive repair contract for that under the franchise agreements. No McDonald's franchisee can have those machines, can have any other machines, and they can't have their machines repaired by anybody else except for the company that is authorized to do the repairs under the franchise agreement and under the master franchise agreement. This accounts for 25% of the business of the ice cream machine makers. And Robert, you'll go on a little bit more, but like the failure rate of these machines is over the top. The revenue derived from servicing them seems a lot, but it's part of the business model, and nobody has any incentive of fixing this. And so what ends up happening is that all these franchisees basically say, we can't repair these machines, we can't maintain them, so we're just going to tell everybody they're broken all the time.
And on top of that, somebody came up with a solution for the franchisees. and they come up with them, help them automatically fix the machines. McDonald's finds out about it and tells franchisees they'll be shut down if they continue to use that. And in the interim, McDonald's makes sure they basically, apparently, according to the accusations, steal the IP from this other company and sell and have the franchisees use that instead. So you have like third-party intellectual property breaches, as well as the underlying scandal. And what people don't understand is like, your AOCs of the world seem to think McDonald's actually pays minimum wage. McDonald's itself pays nothing. McDonald's just franchises out. Watch the documentary on the founder of McDonald's, because it ain't the McDonald's brothers. They got the whole thing stolen from them because the guy was a sharp salesman and even had a smarter lawyer who figured out that if you own the real estate, you really own McDonald's, and was able to screw over the original brothers who actually were the inventive, creative ones to come up with the idea that has made McDonald's popular. And if you've been in any kind of franchisee litigation, you know franchisees get screwed all the time. The people paying minimum wage are your mom and pop local McDonald's, kind of like the ones featured in the first Coming to America film. It's, they got their own little McDonald's. They're trying to do their own little thing. They're trying to, and they're barely surviving usually. And wages are a huge portion of their deal. So minimum wages, that's who minimum wages impact more than anybody. Unlike AOC thinks, it's not some corporate behemoth that it's going to really impact. It's some little mom and pop shop that it's going to impact. And I say this as someone who's a fan of raising the minimum wage in general. But we have to be realistic about who it actually impacts and who the burden falls on. But in that context, this was just one more example of big corporate McDonald's screwing over its own franchisees because it had an inside deal with the provider that gave them a monopoly, so that that gave them sweetheart kickbacks to corporate central to screw over the local franchisee and then to screw over the customer as well. And so it just shows how these people are, the dangers of monopolies, the problem of the whole franchisee structure, and how corporate,
I think that type of provision might be problematic under Canadian franchise law, but I imagine it's more could not call it the Wild West, but it's more like merchant beware in the United States. The franchisor can pretty much include whatever they want in their franchise agreement.
And that's because they pass a lot of state laws that screw people over. Same thing in the storage business. There's a bunch of laws that the storage business has got people to sign off on in various states that basically make them immune no matter what happens to your stuff while it's in their storage. So it's just one long extended scam.
All right, now I'm not going to read this one out loud, but it's going to be the good segue into, let's get an update on the Arizona audit. What is the most recent update?
And from what I've seen, they reached a partial settlement because they're more focused on the computers and the routers than they are, and whether the ballots came from China, maybe, rather than whether or not signatures match. Because my understanding, they've reached a settlement that they're not even going to meaningfully match the signatures. So, again, this was the deleterious effect of the Linwood insanity and the Sidney Powell insanity and all of that Dominion insanity. So they'll get in. I understand they're blocking them. Dominion will try to protect its IP, so they'll block router access and a bunch of stuff. They'll make a big deal about it. So hopefully sooner or later they will get to see that, because that should be part of the transparency of the process. But they're not going to find evidence of what they think they're going to find in that space, in my view. So we'll find out. I still support, obviously, the audits are good transparency, but if there's a reason Democrats were happy to give them all the computer access they want, all the ballot access they want. Just don't look at those signatures. That was the settlement terms, and Arizona Republicans were suckers enough to take it because they're down this rabbit hole that Linwood and Sidney Powell dragged them off to, sadly.
All right, now, before we get into the next subject, 7,100 people watching. Let's make the thumbs up go up, because from what I've been reading in the chat, they appear to be under 2,000. Oh, and also, while we're at it, drop a comment in and let's just see the comment section go crazy.
Especially for the last month or so, YouTube has had something weird going on with likes. So I've liked videos that all of a sudden it unlikes my like, and I like it again, and it unlikes it. So YouTube's doing some weird manipulation again.
No question. My Kim Gardner video was initially demonetized, upon upload, which means that nobody saw it. It's strictly the audio transcript that it's getting. And people have been complaining about getting the notifications for live streams 6 hours to 6 days later. So people were just saying they got not the Samuel, not JD Vance, sorry, Joe Kent. They only got 4 days later. So whatever. Let's see where we go. I got one. Knoxnet says, thank you, David and Robert. Great content. Well, speaking of great content, thank you very much, by the way, Knoxnet. RFK, what's the status of the lawsuit? I know nothing of this one, so you might have to carry it.
So the Children's Health Defense has been discriminated against for about a year overtly by Facebook. And they found out Children's Health Defense is founded by, I think it's Children's Health Defense, by Bobby Kennedy Jr., Robert Kennedy Jr. And so they filed suit and they brought some unique claims, not only under the Lanham Act, but they were able to find evidence that government actors, state and federal, had basically conspired and colluded with Facebook to target them and to prevent them from even having a donation button. And so, and not only that, you get flagged now if you put up anything that they advertise or that they promote or they discuss. And again, all they really do is take what's in the federal government material, state or other material, like what, the VA, I think it's the VAERS system,
yep,
which is a federally mandated system, by the way. It's the reason why they have it. They don't do it voluntarily. There was a big hit piece on it this week by the media that was saying, oh, this can be reported by any person can report an adverse event related to a vaccine. Well, that part's true. What they left out is it's a crime if you lie about it. So it's the most strongest incentive to make sure you're accurate in whatever information that exists. But looking at that data, looking at other medical data, Brett Weinstein has been doing extensive discussion of all the risks related to this, including risks just that you may create, from an evolutionary biological perspective, a more dangerous variant if you try to do mass vaccinations in the middle of a pandemic. He had a Dutch doctor on that. He talked about what Joe Rogan talked about. He's talked about the Wuhan lab related issue, which you can see it hush hush at vivabarneslaw.locals.com.
And now, Robert, these are sensitive issues, and I don't want people think neither of us are doctors, but no,
absolutely, none of us are medical professionals, and I personally have no doubts whatsoever that our white lab coats wish the best for us, and that Bill Gates wishes the best for us, and I'm sure China, by the way, had nothing to do with it. Just to be clear for the YouTube record.
There was Dr. Z-Dog, who I was on, was the first panel I was on with the Rubin Report, Dr. Z-Dog and Dr. Drew. And Z-Dog he responded to this idea that mass vaccinations in the middle of a pandemic can create a variant. He responded to it, and there's discussion about it. The issue is there is and should be discussion on these issues,
and that's Brett Weinstein's point. His point is that we need to have a robust public discussion so that we think through everything and have a good cost-benefit analysis. As George Gammon did a recent video about what's happening in Colombia, political protests there, severe unrest that really all relate to the Colombian government's inability to print their way out of the problems created by their lockdown in that country. And in part, it's because, as he pointed out, there wasn't meaningful debate within the country, just like there wasn't meaningful debate in most parts of the world about a cost-benefit analysis, a risk-benefit analysis. And that's what Joe Rogan was talking about, whether something's good for an individual may be different from a group perspective, and that there should be meaningful discussion and debate and dialogue, and that instead what the institutional powers that be are saying is we can't have such a discussion, we can't have such a dialogue. And all Bobby Kennedy's been doing is we need to have a discussion and a dialogue. And so that's what his Children's Health, and basically their argument is Facebook was acting as a government agent. The government cannot delegate to others what it itself is prohibited from doing. And they had oral arguments this week in the Northern District of California. And if the court there's enough allegations for that case to go forward, if the court is willing to buck Facebook in San Francisco, which is the big political question, then it's a case that should go forward. And it could be a critical case to prevent the government from using social media as its proxy to suppress and censor speech about a core issue. I think the way Bobby Kennedy put it is it's a potential coup d'etat against the First Amendment to the United States Constitution, which is the foundation stone of American liberty. And I agree with him in that respect. So I hope the suit moves forward. They have an above average chance for it to move forward, but we'll find out soon enough.
And everybody, first of all, I'm going to read Cleopatra. Welcome. Thank you. Thank you, Robert, for the locals board this past week. It kept me sane. The locals board, I've been contributing more, but Robert, you are definitely the most prolific.
And it's great for all the board members. I mean, it creates a community of shared interest outside of either censorious control or algorithmic manipulation. And I'm increasingly, it's my primary source of information because there's about 200 posts a day, 1,000 comments a day from an above average. It's like Lake Wobegon at the Viva Barnes Law.locals.com board. Everybody is above average.
I don't know what the Lake Wobegon reference was, but I was going to say it's like
Garrison Keillor.
I was
don't know Garrison Keillor? Oh, great comedian. He got in a little Me Too trouble, but before that, great comedian. And he did a.
I was going to say our locals page is like Twitter without there's still, I won't call them trolls. There's still some vocal disagreement, but it's like Twitter with a more refined filter on the information that makes its way onto the board. It's like Twitter without the rubbish, and it's fantastic. Okay, and
this is my little counter troll for some of the folks that were irritable about the George Samueli sidebar interview. You can watch it yourself. Available up on YouTube. It's a little Moscow shot glass. It was a gift from somebody. So I'm drinking to those trolls that were upset about anything in support of as they perceived it, of Russia.
You're drinking a scotch out of a Moscow cup. This is
yes, exactly. It's apropos.
Nick, Viva Barnes. By the way, just this response to one of those Facebook is a private enterprise argument, and we can't stress this enough. They're a private enterprise, but if they are censoring ostensibly at the direction of or at the behest of government, they lose that status. They lose it in a sense where they become government actors, and they might be held to government standards in terms of censorship and the way they conduct themselves. So you can't call you're not a private enterprise just because you call yourself one, but you respond. You're a quasi-monopoly, and you respond to the direction of the government, then you are held to a different legal standard of what you are allowed to do. And may that day come, because it's quite clear that we are entering in a sense a very fascist state. Fascism by definition is big government working in collusion with big tech to stifle the masses.
Exactly. So that's why it's a very precedent and critical case, and hopefully it moves forward. And whatever people's political disagreements may be with the Kennedy family writ large, this is a case that should bring people together across the board who simply care about free speech. And he's been willing to be the political leader to help try to make it a reality.
I heard someone on CJAD daytime radio. I have to stop watching it because it does nothing but irritate me. But what they were saying of RFK and who they were grouping him with in terms of, theories or theorists, it is as though they only get their information from the mainstream media, which itself has no interest in depicting RFK in any reasonable or accurate sense. It's atrocious. But okay, one thing, maybe it wasn't on the list, but it's going to be a quick one. And I do want to give Rebel News the required publicity, the shout out that they deserve, because they're running into big problems now, and it's been like one step after another with them. They get demonetized on YouTube. Now they've had PayPal cut them off overnight, and they were doing millions with PayPal. Cut them off overnight. And the question is, what recourse do they have? Now, Ezra Levant yesterday with Rubin said they're suing in Canada. I don't know exactly what the contracts is in Canada. I mean, I use PayPal, but not in the numbers and not in the extent that Rebel Media was. But so I don't know if they have an arbitration clause in Canada, but I suspect they have the same arbitration clause everywhere. What can Rebel Media do in terms of suing or going after PayPal, and what's the prospect of any such lawsuit?
And their best chance was likely going to be in Canada, because at least there they don't have to deal with Section 230. Generally speaking, PayPal requires as a condition of accessing its service that you agree to arbitrate and to do so under California law. So that's going to be the hurdle. But it's probably it's a very uphill battle in the United States, because PayPal, again, all of these templates started with Alex Jones. So PayPal did this to Alex Jones, and there's not much he could do about it. And so they used Jones as the way to figure out what they could get away with, and they got away with a lot. Now, he responded by creating alternatives and independent structures to be outside of the system, and the dedication of his audience allowed him to do that successfully. He might have had some legal counsel along the way to assist in the process. But it's very hard. That's the short answer. Very hard. The only shot is likely in Canada. Low chance of prospects in the States.
No, I mean, and what's the benefit? Well, I mean, what the problem is, like, show me the person, I'll find you the crime. that they will, Rebel Media is outspoken. Rebel Media, they are activist media. If that's a bad thing, take it for what it's worth. But they are the only people in Canada talking about certain things. I just know that it's going to be very easy for PayPal to find one thing to hang their hat on to justify ending the contract.
And the bigger problem is their terms basically allow them to do whatever they want, whenever they want. That's the problem. So it becomes about arbitration enforceability, forum clause choice enforceability, and then the because these are take them or leave them contract enforceability. And you do have some jurisdictions that are better than others on those three subjects that say, well, even though that when you have basically adhesive contracts, it used to be the case those were not enforceable against the consumer. If it was a take it or leave it deal, 300 pages, they're like, that's not fair. But in the US, they've turned the tide on that.
Well, and we have it in Canada, and it's typically they're not enforceable, or they're read contrary to they are read in favor of the consumer. The only issue is Rebel News is not going to be a consumer here. They're not going to get consumer protection. They're a business, and so they're not going to get certain protections that would otherwise be afforded to consumers. It's an uphill battle. I just hope they can turn it into a positive, because this is literally what Dan Bongino was talking about, having to create parallel economies and having something of a cold civil war. I mean, this is, you see people building it, and it's hopefully Rebel Media's, they seem to have a team. They'll deal with it and they'll work around it and maybe even turn it into a plus. But this is
it's the utility to what Locals is doing. The reason why I promote it, people have asked, do I have an investment interest? I have no investment interest in Locals. And in terms of the amount of time I spend on the at Locals, at vivabarneslaw.locals.com is not financially rewarding compared to the time I spent legally. It's because I believe in the platform. I believe in its capacity. It's the best alternative out there currently, and they have the right people involved to try to make it a reality. And this is the PayPal Rebel News is just one more illustration of that. That the infrastructure of big tech is being turned on to employ a Chinese social credit type system that is going to suppress and oppress and censor according to political speech, even for relatively mainstream. I mean, Rebel's on the right, but it's not like, they're Richard Spencer or something. I mean, they're just, voicing news about lockdowns and putting preachers in prison, and that being a bad thing to have happen.
It's atrocious. If everybody out there watching, I suspect this crowd overlaps in large part with Rebel Media, but go check them out with them. There are ways to support them and let them know, let them know that you support them and help them through it. Cause I can only imagine the business headache that causes. Now let me hear.
Oh yeah. It's a huge hassle.
Ian Hall, I thought it was almost a joke of a question before. Oh, I shall ask again, the retainer fee. Mr. Frost, je sais, je comprends la jalousie, but Mr. Barnes, the retainer fees. I'm out for the Constitution and the citizens' rights. Email Robert Barnes. I guess you can get your email off the website, Barnes Law. Or
you can, the general contact page at barneslawllp.com comes to me. So I get that. Now, I get hundreds of emails a day. So I will try to read and review it, but I mean, hundreds just from contact forms and other things. I mean, total emails are thousands a day. So I try to get to what I can get to in the order I can get to it.
Although you can get to him through Locals, and you can get to both of us through Locals. Okay, what do we do? We have a few minutes left? Is there one subject that we did not broach that we said we were going to broach? I see.
Oh yes, just kind of briefly, which is people raised questions about the Navalny case on our from our broadcast sidebar with George Samueli, which is part of the Gaggle, who you can also find at Locals now, thegaggle.locals.com. I'll actually be posting there daily on foreign policy questions and issues because I like the independent perspective that they bring. Don't have to agree with them, but you should get that kind of independent perspective because you don't get it from the institutional press. But on the Navalny case, there's two things with the Russian criminal justice system. One is a general criticism of the system writ large. The second is how did it work specifically as to Navalny? As to the general system, my main criticism of the Russian criminal justice system is my main criticism of almost every criminal justice system, which is my view is the rate of human error is too high for a criminal justice system to produce convictions over 80% and be about accuracy and justice. And so I think any system that has an over 80% definitely if it's in the 90s, but over 80%, is a system that really is not achieving the degree of accuracy and particularly protecting the presumption of innocence that I believe every system should. Now, a lot of legal systems don't even have that as a value, but I believe in it. So in the Russian system, their conviction rate's in the high 90s consistently. And so I'm a critic of the system for that reason. I believe it's too deferential. Now, to its credit, particularly under Putin, frankly, they've actually expanded jury trials that never used to exist in Russia for a long time, but it's still not big enough. I think the legal reformers in Russia have documented how once Russian jurors participate in the jury system, their views change from being skeptical to positive once they go through it. And especially if it's used the way it's supposed to be, not like our American federal system is used, which basically tries to use it as a rubber stamp for even questionable prosecutions. If it's done the way it should be used with meaningful jury selection in the process, it will dramatically reduce those conviction rates to get more closer to accuracy. But that's the main criticism I have about the system. Otherwise, you have a lot of the same rights that you actually have in the West, which is also new mostly to Russia. Now, on the flip side, as to Navalny, and again, Russia's criminal high conviction rate still less than Japan. So, the U.S. federal government, mid-90s. So, I mean, it's not like we're that much better, unfortunately. And Japan is actually worse by that metric. Now, as to Navalny got treated better than the average criminal defendant. He had a fraud case. He's been found accused of fraud over and over and over and over again. And it has the same kind of pattern. And the accusers are not usually initially the government. The accusers are other individuals who feel they were defrauded. In one case, it was one of his co-complicit parties who tried to shift the blame. But Navalny, unlike most criminal defendants in Russia, actually had one of his cases overturned by the Supreme Court because he destroyed the evidence. They said, you know what, there's inadequate evidence. So because, nice little twist. And then in another case, he got straight probation, where most other defendants got time. So from my review, the main criticism by the European Commission on Human Rights in the Navalny case was basically the way Russia's criminal law punishes corporate fraud, which is Russia's relatively unique, but there's other jurisdictions that do this, that say if you're the head of an organization, you're responsible for anything that takes place by your organization, even if you didn't personally do it. Now, it's interesting to hear the European Commission on Human Rights say somehow that's a human rights violation. That was kind of interesting. It's, it's that you should have a human right as a CEO that not to be blamed for the fraud of your company. It's kind of a peculiar human right to focus on, especially while Julian Assange sits in prison in a hardcore isolation facility.
Well, that video went viral on social media. Cernovich tweeted it. Pasovic did. The president of Azerbaijan reprimanding the British reporter about her lecturing him about Azerbaijan not being not having free press and not being a free society. And he went on for quite a while to illustrate, not that who are they in comparison, but that they're actually better than the Brits, and they don't have journalists sitting in jail even after having been effectively acquitted.
Maximum security facilities with child molesters and rapists and terrorists. So who's experiencing, according to the court's own determination, severe health problems, mental health problems because of where he's at. So that's so in my review, Navalny got treated better than the average defendant in Russia. The criticism of the European Commission on Human Rights, I get it, but it's not really specific to Navalny. It's a criticism of the criminal law in Russia, which is it's a political disagreement more than, hey, this guy was targeted and treated unfairly compared to other Russian defendants. And while I'm not a fan of the Russian criminal defense justice system, it's a dramatic improvement over what they used to have. And frankly, it's only slightly worse than the U.S. federal criminal system. And they lock up a lot fewer people in the United States. It's always weird for the U.S. to run around criticizing the rest of the world for criminal justice when we still have the highest incarceration rate in the world, and we're more than double the rate of Russia. Yeah,
well, incarceration is a business in the States, so you got to keep the business good.
As a guy on Twitter admitted, a guy on Twitter who invested in it, talked about how much money he made, and he told people go to states that have hardcore that crack down on criminals because those are the ones that really make you cash. So I think there's the interesting thing about all the Navalny defenses. This will be a little, duck, duck, go test for anybody out there. Try to find the sophisticated defense that says Navalny's actually innocent. Not that there's procedural or substantive arguments that they have about the Russian criminal justice system in general, or about how they prosecute corporate fraud. There's a lot of people in America who would actually agree with that system of prosecuting corporate fraud. But see about people trying to argue that he was factually innocent, because strangely, that's mostly lacking from these reports.
Someone just said my likes button took 3 tries before it stayed on. Well, we got through the stream, so there's that. All right, Robert, leave us. So everyone, there will be no stream tomorrow. Next week, also, it's going to be Saturday because I've got a family engagement on Sunday, which I also must respect in order to remain happily married. So next week is Saturday. Then we're going to go back. Next week on Sidebar, who do we have on Wednesday?
I believe it's Razor Fist.
Oh, yeah. Okay, good. Learning curve for me just went straight up. Let me see here. Let's see this. Oh, I just got one. By the way, David, nice job calling out ex-Labor Secretary Robert Reich's BS about Elon Tesla plant COVID dangers versus... Oh, thank you for reminding me, because this... Next Saturday is my wife's 40th birthday. I've just been told. We'll deal with that over the week. But in Montreal, the media, for anybody who didn't see, I did the video of, being on the streets of the protest. And I said, how's the media going to depict this? Yada, yada, yada. The media, being what it is, blamed a interruption of the vaccine rollout on a 4-hour protest in downtown, in the Olympic Stadium where the protest was, because there was a dispensing vaccination center on the other side that was actually not interfered with, but they just rescheduled those 12 vaccination, or there was a few dozen. But the media just today is all over the place. 5 COVID positive people came in from Lanaudière, a region in Quebec. 5 of the estimated 100,000 people that were there, when the positive infection rates are more in the general population. I mean, it was the exact same twisted reasoning. You just give a number and attribute blame when that number in the statistical scheme of things is insignificant and actually proves the opposite of what they're trying to prove. And Robert Reich was doing the exact same thing. 100 cases at a Tesla plant because greedy bastard Elon Musk insisted on opening up early. Fails to mention there's 10,000 employees there that have been working there for however many months. And that statistically, it was twice as good as the state as a whole. So yeah, thank you for reminding me of Robert Reich. Just terrible. And he does it over and over again. It's just, he's playing on the ignorance of the people who follow him and who just unquestionably swallow the drivel that he spews. Robert, let's not end on the cynical Viva. End on an optimistic Barnes.
Well, as one of our commenters on our locals board provided, he recently went to his kid's college graduation. I think it was Ouachita Baptist, if I recall right. If I mispronounced the name, pardon me in advance. But what he pointed out was it was a classic white pill moment, which was to see these kids excited, optimistic about the world because they've received an independent education outside of the gatekeeper's control, with their ability to resist the institutional narrative across the board, which is part of what this show is all about, what part of the locals narrative is all about, is a sign of the ability, as he himself said, reminded him that in his darkest moments, to remember that graduation as a sign that the world can change and likely will change in the right direction, because the greatest trick the devil ever pulled was convincing people he didn't exist. And the greatest trick the system ever pulled was convincing you couldn't resist. So if you resist that trick, then you too can help change the world.
Amazing. Everyone, thank you very much. Robert, we're going to figure out what we do for next week, but stick around. We'll say our proper goodbyes. Everyone in the chat, thank you very much. Thank you for the support. Thank you for the comments. Thank you for the always entertaining discussion. Stick around. You're going to see us next week for sure, but enjoy the rest of the weekend and have a good night.
Happy Mother's Day.
Happy Mother's Day. Jeez Louise to everyone out there.